When you become a member of Inland Empire, Orange County, or San Diego County gun owners, you join the other members as plaintiffs in key cases working to defend and restore your Second Amendment rights. Mike is up next with an update on the lawsuits.
But first, Gun Prom is coming to the Inland Empire. Get your dresses and suits ready. Dust off them dancing shoes. Get ready to celebrate and support the Second Amendment. Join us in our Second Amendment supporter November 12th, 2022 at March Air Museum in Riverside. You can celebrate the delicious food, drinks, and dancing. Don't miss your chance to win some amazing prizes and support the Second Amendment at the same time. Get your tickets now at gunprom.com.
So we were talking a lot about the election. We've been talking a lot about a lot of stuff. We just talked with Dan Was about a lot of things, but we focused a little bit on the Bruen case, which is enormous, the Supreme Court decision.
Okay, so explain it to people in case they just tuned in.
Sure. The Bruen case out of New York, which is where Dan's from, is a historic and enormous victory for Second Amendment. The decision came out in June, basically getting rid of – it did two things. It got rid of the subjective requirements to get a carry permit in all 50 states. So California, New York especially, there were only about, there were 3, 4, 5, something like that, 6, 7 states where they had this weird subjective good cause requirement. Got rid of that, but then the other thing it did is it said, look, all lawsuits from here on out, judges have to look at this thing from a historic perspective. What's the text? What's the history? What did they actually mean when they wrote it? Huge victory for the Second Amendment. You can't look at it through this weird prism of, well, it's 200 years later and now it means something different than it meant. Or heck, it's 10 years later.
Mm-hmm.
It's 10 years later and now it means something different.
Is that why we're not hearing anything about it?
Really? It's so that's what we wanted to talk about. So what exactly is going on? All right, so we got this great lawsuit. What exactly is going on? I wanted to touch on all the lawsuits that San Diego is a part of. Many of them, Orange County and Inland Empire are also a part of. Huge thanks to Firearms Policy Coalition, who we partner with. We get a lot of questions. How do we work with other Second Amendment organizations? And the partnership and friendship that we have with Firearms Policy Coalition is a perfect example of that. They don't do what we do. We don't do what they do. So together, this is one way we can work to continue to solve the problem. So I just wanted to make everybody aware. And you can go to each of the websites, San Diego County GunOwners.com or OrangeCountyGunOwners.com or InlandEmpireGunOwners.com, and then /lawsuits. If you add that extension, you can see an update on all these different lawsuits and what exactly we're doing. So let me touch on it. First, let's talk about the Wynn versus Bonta. Bonta, of course, is the Attorney General, and Wynn is one of our members, Michelle, and it's Nguyen, Michelle Wynn. This is the challenge to California's 1 in 30 firearm purchase ban. So essentially, what California has required by law is that you can only purchase one firearm every 30 days. And we decided, you know what, if this is a constitutionally protected right, then that type of limitation is, of course, unreasonable. So we're taking it to court. And if you are a plaintiff of San Diego County Gun Owners, that means that you are a plaintiff, one of the plaintiffs in the case. We're very, very proud of that. So what's going on with it? Like all lawsuits, it's a big wait and see. It's a hurry up and wait. So we got to wait to get our day in court. We got to wait to get the judge to do their decision. But just know that we are working hard in that lawsuit, and within the next couple years, we will get a final decision that 1 in 30 law will be struck down. The next is the Jones versus Bonta case. That challenges the ban. It's an age-based ban so that adults, law-abiding, sane adults who are 18, 19, and 20 years old cannot purchase a gun in California. There are a few very minor exceptions, but for the most part, it is an age-based ban. So Jones versus Bonta is going to challenge that. Now, the importance of that is it's basic. It's going to say, hey, look, if this is a right, once you're the age of majority, you get that right. Like, this isn't a secondary right that only some adults get. So the Jones versus Bonta case is looking to get rid of the 18 to 20 age-based ban on purchasing firearms. Now, I think the one that most people have heard of the most is Miller versus Bonta. That challenges California's assault weapons ban. Now, Miller is one of our board members, Jim Miller. San Diego County Gun Owners is also a plaintiff in this case, which means that all our members are plaintiffs as well. And at first go-around, this is, Judge Benitez struck it down and said, yeah, this is not constitutional, but then immediately put a stay on it, meaning that, hey, my decision doesn't go into effect yet, because he knew immediately there was going to be a challenge. So he basically said, look, let's get this challenge, let's get to a final decision quick, rather than these back and forth. It's legal 1 week, it's not legal the next week, which is kind of what happened with the MAG case. But that is the first time in U.S. history that a court has ruled against an assault weapons ban. That's good. That's good. So it was kind of in a holding pattern. It was kind of working its way up. Then the Bruin case that we talked about, the Supreme Court case, came down, and the Supreme Court said, all right, back to the drawing board. This Miller case, you need to go back and you need to revisit this thing, and pretty much get another decision. So all the memos have been submitted. All the information that Judge Benitez has asked from the state and from our attorneys has been submitted, which means that by the end of the year, we're probably going to have some kind of decision from Benitez. Now, what happens from there? Not sure, but the cool thing is the decision that he wrote was very much in line with the Bruin decision when it comes to, text and history. So I'm looking forward to a very good result from the Miller case.
Then they appeal it?
That's all possible, yes. They could appeal it, go to the Ninth Circuit Court of Appeals,
maybe up to the Supreme Court.
Could go back up to the Supreme Court. All that could happen. But you got to understand just how clear the decision is when compared to the Bruin decision. You look, it's like carbon copy. The Bruin decision and the Benitez's decision.
So it's almost like, okay, Bruin went through. This one probably, because of the language, it'll be hard to fight.
Extremely hard. Extremely hard. The Renna, let's go to the next case. Renna versus Bonta challenges California's handgun roster and self-manufacturing bans, particularly the handgun roster. This is a safe handgun roster where you can't purchase certain firearms unless it has technology that doesn't exist, this micro-stamping. Renna is actually my former neighbor, and she went to another state, and she was in another gun store, and she was looking at handguns and found a Smith & Wesson Shield EZ, and she has issues with the grip, her hands, and found that she could rack the slide on an EZ and said, hey, I want to own this in California. And they said, nope, can't do that. So it's almost an ADA thing, right?
Yeah.
It's almost
you can't mess with those guys.
So we firmly believe, now that's working its way through, we firmly believe that we have an extremely strong case that falls right in line with the Bruin case, the Bruin decision. And so that's what we're doing to challenge the handgun roster. And then two more real quick. One is Farr versus San Diego, which challenges the city of San Diego's ban on 80% kits. The 80% kits are raw material that people would, turn into firearms, then, of course, register them, et cetera, et cetera. We are suing there. And then the Barba versus Bonta is with FPC. That's the Second Amendment lawsuit that protects gun owners' privacy. It used to be the Brandeis versus Bonta case, but that's so that the state cannot release your private information on gun owners and ammo buyers to a third party, like research folks that want to ban your guns. So those are the lawsuits. Check it out by going to any of the websites: San Diego County Gun Owners, Orange County Gun Owners, Inland Empire Gun Owners /lawsuits.
You are definitely a bee in their bonnet.
That's exactly right. We're more like a hornet in their bonnet.
Thanks for watching this clip from Gun Owners Radio. You can watch us live every Sunday from 4 to 6 p.m. California time, right here on our YouTube channel, or if you're in the San Diego area, you can listen to us on 1170 a.m. We're also available on your favorite podcast platform for free. Don't forget to like and subscribe so that you can help restore and protect the Second Amendment, not just in California, but across the country.